Hello, thank you for joining us for this edition of the People's Law School. My name is Will Kautz, and before I introduce myself, allow me to introduce the participants. With us is Chris Hollowell, an assistant Commonwealth's attorney who's been practicing law approximately 9 years, mostly in the Commonwealth Attorney's Office. We also have with us today Tony Kitchen, who has been practicing law around 8 years and has also primarily been a prosecutor for the majority of his practice. My name is Will Kautz. I'm a partner in the law firm of Bryant & Kautz. I've previously been the directing attorney of the Public Defender's Office. I also spent 6 years prosecuting felony cases in the Commonwealth Attorney's Office. I may add that that is presently what both Tony and Chris are doing. The topic is sentencing options. Basically, in the 28 years I've been practicing law, the laws have gotten much more severe as far as penalties and potential penalties. Sentences have gotten longer, parole eligibility has gotten longer, and I think the legislature has reached out to find inventive ways to try to ease the problem of prison overcrowding. If you would, Tony, could you cover some of the current parole eligibility rules? And I'll perhaps, since I was here 28 years ago, I'll try to contrast that with some of the rules as I remember them 28 years ago.
Sure, thank you. Well, I'd be happy to. Well, first we're going to start off with the premise that a defendant has been sentenced to incarceration and that he is serving time in the Department of Corrections of Kentucky. For most felony offenses, the parole eligibility is 20%. That means a defendant would have to serve approximately 20% of whatever sentence is imposed upon him before he would be eligible for parole. Now, at that time, a parole board would meet and decide whether or not to keep the defendant incarcerated, maybe put him in a halfway house, or go ahead and grant the defendant full parole. Now, that is for most felony offenses. Now, there are some caveats to that. For instance, if a defendant has been convicted of being a first-degree persistent felony offender, and the underlying felony offense for which he was convicted is a Class C felony or higher, then he would not be eligible for parole until he had served at least 10 years of whatever sentence was imposed upon him.
And if you would, Chris, can you, and we'll get back to the 85%.
Sure.
If you would, since Tony has mentioned persistent felony offender, what can you give just a brief overview of what that is?
Sure. The persistent felony offender statute is designed to enhance the punishment for a criminal offense based upon a number of prior felony convictions that an individual defendant has received. And in Kentucky, we have two persistent felony offender statutes. We have a second-degree persistent felony offender, which means that within 5 years of the present felony offense, that the defendant was either on parole or released from prison within the last 5 years for committing a prior felony offense, that the person was at least 18 years of age when he committed both offenses, and that he or she is now more than 21 years of age, and that they received a sentence of 1 year or greater for each offense. First-degree persistent felony offender requires at least one conviction, much like second-degree persistent felony offender, within 5 years of the present offense, but it also requires an additional prior felony offense, and that prior felony offense could have been committed at any time as long as the offender was more than 18 years of age at the time he committed the offense. So offenses that are committed by juveniles, even if they are felony offenses, even if they're certified as adults, don't qualify for persistent felony offenders sentencing.
If we're talking about one prior felony and then the individual commits a new felony, typically speaking, how elevated is the sentence as a result of the PFO?
Well, when we talk about a second-degree persistent felony offender, it we need to keep in mind here that we're talking about felonies. If a person commits a Class D felony and they have a prior conviction which makes them a second-degree persistent felony offender, then that generally enhances it one level of punishment. So if it's a 1 to 5 year sentence, instead of looking at 1 to 5, the sentencing range moves to 5 to 10. If they committed an offense that has a penalty range of 5 to 10 years, then it moves up to 10 to 20 years. And if it's a Class B felony, 10 to 20 years, then it moves it up to 20 to life.
And
that's for the second-degree persistent felony
And then if a person has 2 or more prior felony convictions, at least one of which is fairly recent, then is it my impression that generally speaking, the sentence jumps up 2 notches?
That's right. The rule of thumb is that it would elevate the penalty 2 notches. So if you're looking at a 1 to 5 year sentence, instead you'd be looking at 10 to 20.
Now, Tony, you've already mentioned if the underlying offense is a 5 to 10 Class C felony
Right.
or greater, then that would create a 10 years without parole situation.
For a first-degree persistent felony offender
Exactly.
conviction, that's correct.
You had mentioned just a moment ago the general rule concerning parole eligibility, 20% of the sentence.
Right.
Does that mean that the person is getting out on a 10-year sentence after 2?
No, it just means he's eligible to receive parole. And again, the parole board would have to meet and discuss whether or not they're going to grant this defendant early release or not, or whether or not he's going to have to serve more of his sentence. They have several options. One is they can say, well, let's put him off to the next parole board and see. They can say, well, we're going to have you serve out your sentence, meaning he's going to have to serve whatever sentence he's gotten, minus any credit for good time or any other jail credit that he's received.
Now, I know that the public has the impression that just about everybody who goes up for parole gets parole. And those clients of mine who are in that situation don't always get that sort of treatment. Are there statistics, Chris, that kind of address how likely it is that a person who is going up for parole for the first time may actually receive parole?
Yeah, certainly there are percentages. I can't tell you exactly what those percentages are. I can tell you anecdotally what my experience is. People in these, certainly you start off with the premise that there's a finite number of jail cells that you can put people in the state of Kentucky, in the Department of Corrections. Now, we haven't really gotten into it, but certain, like one of the issues that Tony's mentioned, a persistent felony offender, first degree, who commits a Class C or above, he has to do 10 years. That's the law. So he cannot be released. These other people, where there is discretion to release them, as those persistent felony offenders stack up in jail, and as you mentioned, the violent offender statute requires that people serve 85% of their sentence. As those people stack up in prison, then they fill up the cells. There's only a finite number, and so somebody's got to be let loose. Anecdotally, what I've generally found is that people who are on short sentences, less than 5 years, are the most likely to be paroled quickly.
Did you say the most likely?
Yes.
And my experience is at least those serving 1 year or 2 year sentences are probably the least likely, and the reason being that there's not enough backup time to worry about putting them on parole, and it's more hassle to supervise them than simply to let them serve the sentence out, which really doesn't sound fair or appropriate. But in my experience, my clients who receive the longer sentences are more likely to actually receive parole first time up.
Well, now, from a perspective of I think as the sentence becomes longer, I think that may be correct. But in my experience, in circuit court, what I've seen is that people who are in the, say, 1 to 3 year range have a fairly good chance of being paroled because they don't have to be on paper for very long. They don't have to be supervised for very long. When you get to about 5 years in the Class D felony range, I think they have a tendency to let those people serve those sentences. And then as it goes up, again, for people who are eligible, people who've committed D felonies and are second degree persistent felony offenders, those people, can have a fairly high sentence. They can have a sentence of up to 20 years. But yet, at least the parole board, I suppose, finds those people to be good candidates for parole because a lot of those do tend to get out.
Now, Tony, we have briefly mentioned something about violent offenders and the fact that there's a different parole eligibility standard in regard to people that are so classified.
That's right, Will. Persons who have committed Class A or Class B felonies against a victim, and that victim is either killed or suffers serious physical injury, would be considered violent offenders. Also, defendants who've committed the offenses of first-degree burglary, which is accompanied by a commission of a sexual offense or an attempt to commit a sexual offense, would also be violent offenders. Also, people who commit the offense of first-degree burglary who also commit the offense of robbery or kidnapping would also be violent offenders. And all those types of defendants...
And let me ask you before you get to that point, rape?
First-degree rape and first-degree sodomy.
Sodomy, first-degree robbery?
First-degree robbery, that's right.
All right, so basically speaking, without going into a litany of every charge that would qualify as a violent offense...
Well, I think we've covered them all.
They're pretty much the more serious offenses.
That's correct. That's
okay.
correct.
And what impact does that have on parole eligibility?
Well, those defendants would not be eligible for parole until they've served at least 85% of whatever sentence is imposed upon them. So that's a pretty significant departure from the 20%
exactly.
rule.
And just for a little historical perspective, and it's hard to remember, you're not there yet, either of you, but it's hard to remember what was going on 28 years ago, I can promise you. My memory is telling me that we had basically a 20% eligibility guideline that applied to all crime, and, believe it or not, the maximum parole eligibility for any crime other than a capital offense was 6 years. You could commit, and from what you've just told me, if a person were to receive a minimum 20-year sentence for murder today, that person is going to be in prison a bare bones minimum of 17.
That's correct.
That's right.
And there's been a shift across the nation, in fact. In 92 was when Kentucky changed their statute. In 92, prior to 92, between 74 and 92, you're talking about a 50% parole eligibility on violent offenses. After that, then Kentucky stepped it up to 85%, which is where we're currently. Now, there is one caveat that we also need to keep in mind. We've talked about violent offenses, and we talked about A and B felonies, first-degree rape, first-degree robbery, murder, burglaries that include commission of a sexual offense. One of the other probation/parole issues relates to people who have used a firearm in the commission of the offense and are prohibited, and it doesn't matter whether it's a B, a C, or a D. The use of a firearm during the commission of the offense, they could be prohibited from some of those lesser forms of incarceration.
And it's my impression that if whatever crime you commit is classified as a violent offense, then even a judge doesn't have the statutory authority to grant probation. Am I correct?
The only caveat to that is if the judge finds that the person was a victim of domestic violence with relation to the commission of the offense, and then he or she can enter a finding in the judgment that says that the defendant who committed a violent offense was the victim of domestic violence as it related to the commission of this offense, and not subject that person to the 85%, where they would be, they would slide back to the 20% rule. And we've had a couple of cases in the 9 years that I've been at the Commonwealth Attorney's Office that have dealt with that issue. One where the judge found no, that the domestic violence exception did not apply, and one where a judge found that it did.
And I think there's also an exception to that, though, that first-degree sodomy and first-degree rape convictions you can't get the exception for domestic violence.
So
That's
what
right.
we're talking
Those
about
offenses.
is an exception to an exception.
That's right.
All right.
That's right.
Sentencing options. We've just discussed that there are instances, first-degree persistent felony offender, where probation is not even an option that the judge could consider. Are there other crimes that fit that category, Tony?
Let's see. Certain sexual offenses, but off the top of my head, I can't think of which ones in particular.
Pretty much,
those
I
would
think
be.
pretty much all of them, with the exception of sexual misconduct.
Right.
Is that not-
Sex offenses. If you add in the element of the victim and the defendant having some type of relationship of special trust,
Right.
Those can even go down into misdemeanor ranges. And also, as we talked about, any offense that's committed with the use of a firearm, or
is there not an exception for a D felony involving the use of a firearm?
I don't believe so. Not with relation to firearm offenses. Now there is an exception of all D felonies. I take that back. That's right. There is an exception within one of the statutes that says any prohibition against probation as it relates to Class D felonies is not applicable. But you also have, and it's one that we don't often see, but we talk about the firearm. It's also a prohibiting factor if the person who committed the offense was wearing body armor at the time that he committed the offense. So, you've had some cases, and really not here in Kentucky, where people went to rob banks and wore body armor to protect themselves in an armed offense. That is also a prohibiting factor in the state of Kentucky from probation or conditional discharge.
Now, we've been talking about instances in which probation is statutorily available to a judge. In my experience, most of these newer laws that prohibit probation under certain circumstances are probably not necessary, at least in McCracken County, because I think we've been blessed with wise judges.
Right.
But if, I guess, the legislature apparently had some concern that some counties might not be so blessed.
Well, it's probably happened in some place in Kentucky where somebody had committed a serious offense and was granted probation.
It sounds as if this conversation has taken us to the point where, generally speaking, sentences have become longer, and very often there's prohibitions against probation, and many crimes apparently now require that the defendant serve at least 85% of the sentence.
Right.
And I might add that it's my impression that that other crediting factors against a sentence, such as good time, are very, very limited as it applies to violent offenses. What has the legislature, or what is the court system doing on the other end? Because obviously the people can't afford to build a prison for every citizen in this state. You and I, all three of us, know that the legislature has created many, many more felonies from crimes that were misdemeanors in the past. What has the system done on the other end as a safety valve to ease the problem you've mentioned, Chris, of prison overcrowding?
Well, you've got statutes that have been adopted that have encouraged judges to to be creative, to be open-minded in the way that they address sentences. And when you start talking about these different sentencing options, there's really two fundamental questions that you try to answer. The first question is, what's fair? Not everybody who commits an offense needs to go to prison to learn their lesson, and that means anything from a misdemeanor all the way up to, various crimes. And the second one is, what can we afford? And so the legislature's taken an approach where they've encouraged judges to be creative and having given them options, including halfway house, sending someone to a halfway house instead of directly to a prison, work release from a jail facility, community work service, also from a jail facility or from their home, home incarceration. We've also, in the state of Kentucky, seen an expansion of drug courts, which is a monitoring program to help people that fit into certain that commit certain types of crimes. But I think that the legislature is trying to give judges options. I talked to Bill Adams today. He told me that it costs $30 a day to keep one inmate in jail. They've got a jail over there that is capacity rated for 347 people, and on average they have somewhere between 460 and 500 people in there on a daily basis. And you can do that for a while, but sooner or later you've got to take a different approach.
It's interesting, Chris. I've lived in this community for 28 years, and I recall when every member of the McCracken County Fiscal Court, save one, was voted out of office because we, quote unquote, built too big a jail. And that doesn't seem to be the case, and maybe those good citizens who were voted out of office perhaps were a little more forward-thinking than they were given credit for.
And that may be, I think that's right. I think that, we really have to kind of be forward-thinking and progressive in the way that we approach. And certainly, one of the things that we have to make sure that people understand is that there are certain levels or certain types of crimes, and we've discussed them here, people who aren't eligible for these kind of alternative sentences. But for people who are nonviolent, particularly misdemeanor offenders, there are ways to get through to people, and I think we'd all agree, all of us having a background in prosecution, that we want to deter people from committing crimes, especially repeatedly. And I think we all agree that you need to try to get through to people. The question is can you get through them? Can you get that message across to a criminal offender or a defendant in a less costly and a less punitive way? Because putting somebody in jail has consequences far beyond that person. Lots of times, the population at the jail is mostly male, and I don't think that's any big surprise to people. But you have situations where in some ways these people are in the jail that are they both male and female, whether they're taken away from families, where it's disruptive to a family unit,
or to an employer. And so incarcerating people has effects in the community beyond because mom or dad has to go to jail. Well, if mom or dad was the one who was making the money in the family, well now there's that much less money that's coming into the household. Do they have to go on to public benefits? So those consequences are far-reaching, and you have to consider that in trying to fashion options, sentencing options, and You know, it seems to me that most good people believe in being tough on crime unless the person who's accused is a friend or family member. I happen to think that and agree with much of the new legislation that encourages options in America, not just Kentucky, other than prison. I'm somewhat taken aback by the fact that one of the most advanced societies in the world probably has one of the highest prison populations. And Tony, before we get to some of these inventive options such as deferred sentencing, deferred prosecution, drug court, can we address some of the statutory issues that a judge is supposed to consider in regard to the question of probation? Because before these other options were made available, 28 years ago when I began practicing law, basically a judge had two options. Yeah, probate, three actually. Probate right now, wait anywhere between 30 days and 6 months, and probate later, shock probation.
Right.
Or don't probate, don't shock probate, and let's see what the parole board does or doesn't do.
Sure.
So what are the factors, statutory factors, that a judge is supposed to look at in deciding whether or not to grant probation, assuming that probation is statutorily available?
Okay. Well, it's interesting. Well, not only does the legislature encourage judges to probate and grant alternative sentencing, it's actually mandated unless certain factors are found, such as if the judge believes that the seriousness of the offense committed would unduly depreciate the seriousness of the offense if the defendant were granted anything less than incarceration. Also, if the judge determines that a defendant would benefit from correctional treatment that he could only be provided for in prison, then he can also choose to incarcerate. Or if the, let's see, what's the last one? If the judge, do you remember what that last one is?
The last one's going to be unduly depreciate correctional treatment or likelihood that the
crime.
person would commit
That's
an
right.
offense if given probation or conditional discharge.
And unless one of those circumstances exist, in a case where the law allows probation, the statute directs that the judge grant
Shall be
probation.
probate. That's right. And I thought that was interesting, and I really didn't understand the exact nature the way the statute was written until I looked that up.
You know, in practice, though, and I know why the legislature passed that law, because at the same time they were passing all these other laws that created, that robbed the judges of options and created extraordinarily long sentences. In practice, it seems to me that a judge is going to do what he wants to do anyway, and then justify it by making one of those findings.
Well, that may be the case, but it's also interesting that the first thing the judge has to do, unless he finds some of these factors, is grant probation. If he finds one of those factors, then he goes to consider an alternative sentence plus some probation and or
So just the
conditional
existence
discharge.
of one of those factors in and of itself doesn't necessarily dictate that probation is going to be denied.
No, you don't automatically go to jail because one of those factors are
And then
met.
there are some other factors that the statute requires that the judge considers.
Well, the factors are basically the same when you're going from considering probation to alternative discharge, from an alternative sentence.
And they would include, obviously, the prior criminal history,
That's right.
whether the offense was against the person or against property.
That's correct.
With offenses against people being considered more serious. I can't recall specifically what some of those other factors are.
And I think that we've
Pretty much
we've
covered.
They're
I
all
think you've
the-
basically
the
covered.
So there's some overlap.
That's right. There's some overlap between how the judge gets to deciding whether a person will be probated or, as Tony said, probated with an alternative sentence.
So a judge can, if I understand where we're coming from here, if a judge wants to, he can grant probation and thereby retain control over this person through the Office of Probation and Parole, but also require that the person go to jail for a while.
Yes.
Up to, is it 6 months?
6 months.
Or
180
a
days.
judge can require as a condition of probation home incarceration.
Home incarceration, that's right.
And then obviously other conditions such as maintain gainful employment. And the biggie, don't commit other offenses.
Right.
Make restitution payments if any are required. That's a requirement for any type of non-incarceration sentence.
Restitution.
Right.
Because it's difficult to make restitution if you're behind bars.
I'd say it's impossible.
12 cents a day making license plates, I guess. But
Right,
I don't really think that we're making license plates anymore in prisons.
And there's several options when we start talking about probation. Conditions that can be placed on the defendant, as you were talking about, restitution, maintaining employment, not committing offenses, additional conditions that seem to come up quite often are entering a drug rehabilitation program, either for 30 days or longer, 6 months. Obtaining an education.
We would all agree that the prospect of rehabilitation for a person with a drug addiction is not very good with one of these 28-day treatment programs. Even a criminal defense attorney would have to agree with that.
Yeah.
And there are longer treatment programs, and I know both of you guys are actively involved in our drug court program. I want to thank you both because I happen to be a big believer in drug court, and that's where we're heading now with this conversation. I think that historically, in the 28 years I've practiced, both as a defense lawyer and a prosecutor, the answer to most drug offenders was lock them up, as opposed to treat them. And I think as a result, prisons, both at the state and national level, are full, largely of drug offenders. Since you guys are both involved in drug court, Tony, could you tell a little bit about what drug court is and what drug court tries to accomplish?
Sure.
And who is a member, basically speaking, or a participant in the drug court program other than the offender?
Sure. Well, the drug court is a very intensive program that select defendants can enter, and the ultimate goal of the program is to get them off of drugs, get them functioning in society, and get them basically back on their feet so they don't wind up in the system another 5, 10, 15 days down the road for committing a new drug offense.
Or other offense.
Or other offense.
Because I think we all would agree that so often many of the crimes that are committed, while they may not be drug offenses, are certainly related to the fact that the defendant or the subject is on drugs.
And I would say primarily related to that defendant's ability to purchase drugs. A lot of them robberies, burglaries, thefts. They all go bad checks even, forgeries.
So if we can address the drug issue or attempt to address it, then we're really accomplishing knocking out a whole lot other than just a drug offense.
That's the theory, and hopefully that will prove true. Now, in our drug court, we have Judge Clymer, who's the head of the drug court. He presides over it, and he makes the final decisions as to whether or not a person might receive some sanctions. But let me talk about how the program works. Once a defendant is placed into the drug court program, they are monitored very closely, both by the drug court program administrator and also from a drug testing standpoint. They're tested constantly, sometimes daily. And I think defendants who have a drug problem need that close supervision. and that seems to be doing better for people than to just say are sent to a treatment program on probation. But as part of, not only are they closely monitored, they also have to maintain employment. They have to have certain tasks that are given to them by the drug court administrator. They have to go to counseling, treatment programs. It's very intensive, especially for the first phase. We've been doing this now for a little over a year. We've got about 25 participants in the drug court now. I think we're slated for our first drug court graduation sometime in the fall, and we have 5 or 6 participants of the drug court program who are hopefully going to graduate. They're well on their way so far. I think they're well into phase 2 and possibly into phase 3.
And it's my understanding that basically speaking, from what you've told me, drug court is actually more intensive and requires more of the defendant than would ordinary probation.
It is. It's very much more intensive, and also the consequences for not successfully completing the drug court program are generally
more severe.
For a participant now to go into drug court, they have to agree to accept the maximum sentence.
So basically, they plead guilty, as I understand it, to whatever offense they've committed. Then that sentencing is basically continued, subject to their participation in the drug court program.
And it depends on what type of track is available to them. If they are eligible for a diversionary track, which means at the end of this drug court, if they successfully complete it, the conviction is taken off their record.
Which basically is the light at the end of the tunnel.
That's the light at the end of the tunnel.
And if, in my mind, if the criminal justice system can take this drug user and get that person off of drugs, then I don't know that society benefits by that charge becoming a conviction, particularly if that drug user is willing and able to jump through all of the many hoops in the drug court program.
Well, I don't know that I disagree with you there, Will. It's certainly the goal of the drug court program to get them back and functioning. And in some of these situations, a felony conviction can have serious consequences on their ability to work.
Exactly. And pull their load in society.
That's right. Now, there is another track that's available for people who don't qualify for diversion, and that's the probationary track. And in that track, they are actually sentenced, but are sentenced to probation. And as long as they are successfully completing the tasks that are assigned to them by drug court, then they get to stay in drug court and they stay on probation. And if for some reason they should fall off the wagon or completely, and just the drug court team decides that that person is not going to be able to complete drug court, then their probation would be revoked.
And the drug court team judge has options other than basically removing this person from drug court or putting them in prison if they do slip.
Taking them out of drug court is the last resort. That's reserved for the participants who just clearly are not going to make it.
Right.
And a lot of times what a judge will do is sanction them to a certain number of days in jail.
If they mess up just a little bit.
Right.
But not sufficiently enough to boot them from the program.
That's right.
Because it's my impression that it's not unusual for people with long-time drug dependency to slip even if they're moving forward. In other words, 5 steps forward, 1 step back, but they're still 4 steps ahead.
That's right. That's actually pretty common, and as long as those steps ahead are generally keeping ahead of the steps back,
all right,
then the drug court team and the judge has been willing to work with that individual.
Chris, we also have used the term, I've used 2 terms today, deferred prosecution, and at least apparently that's, and we've used the term deferred sentencing. And I know in McCracken County, the drug court program, at least one track, is basically a deferred sentencing program. What can you contrast the difference between a deferred prosecution and a deferred sentencing?
Well, deferred prosecution does not require that a defendant enter a plea prior to some type of resolution, whereas the deferred sentencing model requires that the defendant plead guilty, that there's a sentence that's out there that can be imposed if the defendant fails to meet certain obligations. On a deferred prosecution model, what happens is the case is held in abeyance or set off to the side, so to speak. A defendant is given certain conditions that he's supposed to meet, and if he meets those conditions, then the case is dismissed and is never enters to an actual plea stage. And we've had, as Tony said, we've had this drug court going for a little bit over a year. The great thing about this drug court, one of the things that I've learned over the process of being involved in this is that, and having dealt with drug court participants from other counties, because there are counties in this region that also have drug courts. Drug courts are only as successful as the people who are running them. If the people that are running the drug court, and by that I mean the judge and particularly the drug court administrator, and in our case Judge Clymer and Richard Swain, do a phenomenal job of staying on top of that drug court. The reason that drug court is successful is because, as Tony talked about, there are consequences. And the difference between normal probation and being in drug court is this. If you're on normal probation for committing a drug offense and you test positive, you get put in jail. And in most cases, people bond out because the bond isn't particularly high on a probation violation warrant, and they go back home, and it takes them a month, sometimes 2 months, before that person is back in court for a probation revocation hearing to decide whether they go to jail to serve their sentence or they remain out. The thing about drug court is that the consequences are immediate. When you test positive, you go in that day. You go to jail that day, so that the participants understand, if I do this and I get caught, tomorrow I go to jail. As opposed to, well, I might get away with it, and if I do get caught, nobody will really decide what's going to happen with me for 2 or 3 months.
Which kind of goes back to just the old adage, which I believe to be true: justice delayed can be justice denied.
Absolutely. And
because my impression, as you've just indicated, is it's not unusual if somebody allegedly violates probation. The first thing that has to happen is somebody has to draw up the paperwork. It needs to go to a judge. He needs to sign a warrant. That paper then need to be processed and served. When the person is served, it may be a month or two or more before the busy court schedule allows for a hearing, and you can be asking a judge as a felony prosecutor to revoke somebody's probation for a single mistake that they made 3 months ago.
That's right. And the immediate consequence of the drug court is really what provides the hammer, because you talked about not all crimes are not all crimes committed by drug people are drug crimes. That's exactly right. In my experience, and I don't think I'm overstating this at all, 90% of the criminal offenses that we deal with, 90% are rooted in drugs or alcohol. Drugs or alcohol are a contributing factor in 90% of the felony offenses that we deal with. When I started working at the Commonwealth Attorney's Office, we prosecuted about 270 felonies a year. Last year we were over 600, and that's a dramatic increase in a fairly short time frame.
And is that because, and it could be for both reasons, is that because people are committing more felonies, or is it because every time the legislature meets, they take what was a misdemeanor and create a felony? I'm talking about firearm-enhanced possession of marijuana, firearm-enhanced possession of drug paraphernalia, and on and on and on.
Certainly I think that's right in some sense. There are more crimes that are there are more crimes certainly than there used to be. I think you can also attribute at least the increase in our caseload to a couple of issues. One, aggressive enforcement by law enforcement. We've had a philosophy that's been adopted by the law enforcement to aggressively pursue all types of crime, and I think that is responsible for at least some of the upturn. The other upturn is we've seen a dramatic increase in the number of prosecutions for flagrant non-support, which are also, oftentimes, again, drug-related. The people aren't out working because they're using drugs.
Or if they are working, they're using the money to buy drugs instead of pay child support.
That's right.
That's right.
And so I think both of those factor in some way into the number of offenses that we're dealing with on a daily basis.
We've been talking about drug court, and it's my understanding that while McCracken County does have a drug court program, and I know we're all proud of it, that according to what, Tony, you've just said, about 25 people are in it.
That's right.
I'm certain that we have more than 25 people in this community committing drug offenses, and that we certainly have more than 25 people who could benefit by that sort of a program. What are the limitations, and why are we limited to 25 people, and at what level is drug court now available?
Okay. Well, it comes down to dollars. Everything revolves around dollars and resources. Right now we have funding. Our initial grant was for $100,000. That would cover about our 25 initial entrants into the drug court program. We're hoping very much to increase our funding for the next fiscal year, and we'll find out shortly if that's going to happen, but we're going to be able to hire another drug court staff member, in which we hope to be able to double the amount of participants in the drug court program. And right now it's only offered through the circuit court. Have to be accused of committing a felony offense to be eligible for the drug court. Misdemeanor offenses only right now are not eligible because those offenses are handled only in district court.
What about drug court at the misdemeanor level? It seems to me that that's where the system should be focusing on the issue, and if we can catch these mostly kids in time, maybe they won't end up in circuit court.
I think in general that would probably be a good idea. However, the drug court program as we administer it now is really for those people who are hooked on the serious drugs, methamphetamine, cocaine, those types of drugs. Now alcohol would be included in that, and I guess from an alcohol addiction standpoint, maybe a district court type of drug court program would probably be helpful as well.
Well, let me ask you this, since you brought it up. Obviously, we all know that alcohol is a drug.
Right, that's right.
Is our present drug court program available to those of us who are addicted to alcohol?
Yes, but then it's not precluded, but generally speaking, participants are selected based upon their addiction. And what we're seeing the most of is addiction to cocaine and addiction to methamphetamine. And
if we could catch, I mean, I personally do accept the premise that very often marijuana, drugs that are certainly less severe than coke or methamphetamine, the marijuana use sometimes leads to something greater, a gateway.
That's right.
And it seems to me that the system needs to be working to catch these offenders while they're still in district court.
I think that'd be a great idea, and if we can identify some resources to be able to help along that. I know they have the Crossroads monitoring program in district court now, which at the defendant's expense, I believe, they are required to undergo random drug testing and things like that if they are sentenced to that type of thing. And that's a good program too, but it doesn't address near the number of people that need to be addressed.
Sure, but it seems to me that that's a direction that perhaps district court should be moving toward,
I'm all for that.
which would, as I understand the present program, the county attorney has initiated a drug diversion program, but it's not commonly used, by which the defendant himself pays for the cost of his supervision through Crossroads.
That's right, and that's wonderful for defendants who can afford that, but unfortunately it doesn't address the truly indigent defendants who have nothing and really can't afford to pay for any of this.
And that's really, in most circumstances, the clients who you find in drug court right now are the people who have literally hit rock bottom. For most of them are not, they're not functioning right now, or when they enter the program, they are not people who are capable of holding down a job because they are so addicted. And you asked the question about alcohol. Could people who are addicted to alcohol get into the felony drug court program? Of course they can. But what you find is that in most circumstances, felony alcohol offenses is a fairly small number. You have to have a DUI fourth offense before you're in felony court. And right now, the only people who are being admitted into the drug court are felony offenders. And so, if you were to reach out to those people, as you're suggesting, at the district court level, maybe you prevent that person from being DUI fourth. He gets the message, or gets a handle on his problem before he gets to DUI 2.
Yeah, it goes back to a stitch in time saves 9.
Right.
And if we can catch the offender early enough, the public may wonder, and this is a question that I guess is better answered by present prosecutors than by a present criminal defense attorney. The public may wonder, why in the world should we worry about diversion or deferred prosecution? If somebody commits a crime, let's just lock them up.
Well, and I think that the answer to that question is that when you look at drug court tries to take a broader view of society's interest in a criminal defendant. And certainly one aspect of society's interest in criminal defendants is to be protected from criminal defendants who might commit other offenses against them. That's certainly one element. But as we talked about earlier, it costs $30 a day to keep somebody in jail. Okay? And Tony's talking about $100,000 for a year for 25 people. Now, if at the end of that you end up with 25 people who are off drugs, you've done society a whole lot better service than you have by putting somebody in jail for 12 months. And when you kick them out of jail at the end of 12 months, they're just as addicted as the day they walked in, because society pays that price. They've lost out on how much it costs to incarcerate them versus to help them, but they also lose out on the back end when the person goes out and commits a whole new host of crimes. Businesses are affected, people are affected, families are affected, and so the cost to society is much higher by not treating the addicted individual.
So your point is, the system needs to address the revolving door.
It does, and I am convinced after a year in this drug court participating in the drug court program, that incarceration alone does not get somebody off of drugs. Incarceration is an effective tool, I think. It shouldn't be off the table, and sometimes it's necessary to provide them the extra motivation to try a little harder to get off drugs, because when it comes right down to it, we can't get people off drugs. They have to want to do it themselves. But it can provide them a little extra motivation. But as I say, incarceration alone is not going to do it.
All right, so and then the question becomes, and it's really esoteric, the goal of the criminal justice system, is it to convict everyone who can be convicted? And I don't even know that the majority of police officers agree that it is. Or is it to correct a problem and try to turn people in a different direction? Or is it both?
Well, I don't think the goal of the prosecution system or criminal justice system has ever been about just getting convictions. I think if you ask any prosecutor, and I'm sure you well know this too, the goal of the prosecutor is to do what's just, and to do that from a standpoint of protecting the public, and to do what's just with the defendant. Nobody wants to be overly harsh on a defendant. They don't want to be heavy-handed. We want to do what's right. And so that's our ultimate goal. The ultimate goal is for protection of the public.
And certainly doing justice is not only its own reward, it provides for confidence in the system, because you want people to certainly to be held accountable for the things they've done. You want to protect the public, but you also want to treat people fairly. A defendant needs to be treated fairly, because when he's not treated fairly, or he believes he's been treated unfairly, or his family believes he's been treated unfairly, then they lose respect for the criminal justice system. And we need the criminal justice system in large measure relies upon people believing that it's that it's due respect. And so certainly the answer is not to throw every person in jail. And as Tony said, it's to do justice both for society and for the individual. And we have to consider both of those in determining what, among all these sentencing options that we've talked about today, and there are, we could go on for another hour about different ways that you can treat people, but that's ultimately our goal is to be just, both for the community and for the individual.
And it seems to me that there are many instances in which, and we've talked about largely leniency today, with the exception of the statutes that prohibit parole or probation. But there are instances, it seems to me, where we're not doing a defendant any favor by being lenient.
No, you're doing him a disservice, because we've got these options, and certainly being lenient on a person or not getting through to that person that there are immediate consequences, or certainly consequences, we're breeding contempt for the system, and that's something that I think has been a problem, frankly.
So it would not only be a disservice to the community, it's also a disservice to the individual.
That's right. That's certainly right. Because he learns to have contempt for the system and believe that well, it doesn't matter how many crimes I commit, nothing bad's really ever going to happen to me. And so, so many of the people that we see in felony court, they didn't start in felony court. They started in misdemeanor court,
right.
But over the course of time, graduated to that level.
I hate to interrupt, but I'm told that our time is up. And I can't tell you how much I've appreciated your participation in this forum, and we appreciate the interest that the public has in this issue. And we would encourage you, to participate in the system by contacting your legislators, and giving your input, because the public has a right to be heard, not only on what's happening in individual cases, but what laws are good and what laws are bad. Thank you very much for viewing People's Law School, and Tony, Chris, thank you for your participation.
Thanks for having us.